Good morning, everyone. I'm Andy Stamp, Associate Executive Director of VAS. Welcome to the VAS McGuire Woods webinar on vaccination guidelines for employers. Before I introduce our presenters, I would like to give you instructions for the Q&A session at the end of the presentation. Your chat box feature has been disabled. To pose a question to the presenters, you must go to the bottom of your screen and click on Q&A. The Q&A box will then pop up and you can type in your question anytime during the presentation. If you see a question in the box similar to the one you're asking, simply click on the question and a message will be sent to the presenters that there is more than one person asking this question. If we run out of time and the presenters don't get to all the questions in the Q&A box, we can download the questions, have the presenters respond to them, and then send the questions and the answers to you after the webinar. Today, we're fortunate to have with us for our third coronavirus-related legal issues webinar, Craig Wood and Micah Schwartz. Craig is the VAS legal counsel and an experienced trial lawyer at McGuire Woods who has taken more than 100 cases to trial in areas of education, employment, commercial, and professional liability law. He regularly defends businesses, higher education institutions, and school boards in a variety of employment and regulatory compliance matters. Micah is a litigator at McGuire Woods who focuses on employment and occupational safety cases. He represents clients in federal and state courts at the trial and appellate levels and counsels clients on sensitive labor and employment matters. Thank you both for presenting today. Now I'll turn the webinar over to Craig.
Thank you, Andy. It's good to be with everyone this morning and welcome to the webinar. Micah and I are going to cover these topics. First of all, we're getting a lot of inquiries and we know you have a lot of questions about whether a school system, a school board can require your employees to receive COVID vaccinations now that they are becoming available. And then a secondary question that's not as much a legal question as a policy question, but we want to talk about the policy considerations is whether schools should require their employees to receive COVID-19 vaccinations, or is the more prudent approach to use a strongly encouraged but not mandatory procedure. And later on, we're going to have a little debate about that question. And then we want to make sure that we answer, to the extent that we're able, any questions that you might have. So the first major question that you have, we know, is can we as employers require our employees to receive the COVID-19 vaccine? And Mike is going to lead off that conversation.
Thank you, Craig, and good morning, everyone. This is Micah Schwartz. I'm talking to you from the McGuire Woods office in Charlottesville. And as Craig said, I'm going to take this first section on whether or not schools can require employees to receive vaccines. Our theme for today is newspapers. You'll notice them throughout the presentation. I was an editor of the school newspaper in high school and have always enjoyed the print on the paper, which you don't get to see as much anymore. So that's going to be our theme as we're going through this. And the headline for this presentation, above the fold in big, bold letters, is yes, employers can require employees to receive the COVID-19 vaccine. If that's what you want to do, you can do it. Yeah, next slide, Craig. The EEOC issued guidance in December addressing this question, expecting that employers were going to start asking it. And what the EEOC has said, at least tacitly, is that a mandatory COVID-19 vaccination program is lawful, or at least in principle is not a violation of any law. And the EEOC is the agency that administers the federal discrimination statutes. And those are the ones that we're most concerned with in instituting this kind of policy. So if the EEOC has blessed it, we can feel comfortable going forward with it. But that's only the big headline. Craig, if you can go to the next slide. There is fine print on the back page, or on A16, if you will, buried in the middle of the newspaper. There's a number of caveats and exceptions to this rule. And as you'll see as we're going through it, they may, in your experience, blow a hole through the whole thing. But hopefully not. We'll talk about each one in turn. So here are the two main issues, which is that while an employer can mandate a vaccination like the COVID-19 vaccine, it has to make exceptions for employees who request exceptions based on either of two bases. The first one is because they have a disability and that they can't receive the vaccine safely because of the disability. And that's an exception we have to make because of the employee's rights under the Americans with Disabilities Act. The second exception that we have to respect is if an employee says that he or she objects to receiving the vaccine for religious reasons or based on religious beliefs. And we have to respect that kind of objection because of Title VII of the Civil Rights Act, what we often just call Title VII, which is the primary federal employment discrimination statute. It protects employees from discrimination based on their religion and requires employers, where reasonable, to provide accommodations based on religious beliefs. And that can entail an exception for to receiving a vaccine if the employee has a religious basis for objecting to it. Craig is going to talk to you about the religious belief exception later in the presentation. I'm going to start with the disability bases for receiving accommodation. So let's state it at its most basic. This is a right afforded to employees under the ADA, and employers must provide reasonable accommodations to employees with disabilities that prevent them from safely receiving a COVID-19 vaccination. This is our obligation, just like it would be for any other kind of disability that an employee presents to us. If we can accommodate it reasonably, we're expected to. We're going to pick apart all of these pieces as we go. If you have questions, please write them into the Q&A section, the Q&A box that you'll see at the bottom, and Craig and I will come around to them at the end. You may find that we're addressing your questions as we go, but we've left some time at the end for Q&A, and so Craig and I will try to get into those as we go. Craig, if you can go to the next slide. So the first question in any disability accommodation case is, what's the disability? Right? We don't have to provide accommodations to people based just on any medical condition. It is only disabilities that we have to accommodate. Now, as a practical matter, as you all have learned most likely, a lot of things qualify as disabilities. And as a practical matter, if an employee wants to assert a disability and attempt to get an accommodation for it, it's usually not that hard for them to do so, because the EEOC and the courts have identified a number of illnesses or conditions as disabilities. But as it applies here, the disability still has to have some relationship to receiving a vaccine. So it's not going to be sufficient for an employee to just identify any kind of disability. You know, imagine an employee who has a severe back issue and has been getting accommodations from the school for it, isn't required to lift heavy things, is allowed to sit down at times, even if that would be unusual for his or her position. He might be used to getting some kind of accommodation from the school, but that doesn't mean he's entitled to any kind of accommodation. And unless he can make a case for why his back issue makes it so that he can't receive the vaccine, he doesn't get to get an exception for getting the vaccine. So the employee does need to identify a disability, but it also has to relate in some way to their explanation for why they can't get the vaccine. And as we go, we'll probably start hearing more and more and have a better idea for what kinds of disabilities are going to be relevant here. But here's a couple that I've thought of and that I think that you might encounter. Number one is the immune compromised employee. So imagine an employee who doesn't have a lifetime disability, but instead has cancer and is receiving chemotherapy treatments and has a compromised immune system as a result. For that employee, it's possible that a doctor will say that the introduction of even a very small amount, a vaccine amount of the coronavirus, is dangerous for the employee. And so at least during the time period of the chemotherapy, it would be unsafe for that employee to receive the vaccine. That is likely going to qualify as a disability under the ADA and be at least a reasonable basis for not being vaccinated. Number two, allergies activated by the vaccine. Lots of you have probably seen headlines of this kind in the newspaper over the last couple months or last couple weeks. There are some individuals who have allergies that are implicated by the vaccine and can have allergic reactions that are potentially more dangerous than COVID-19 itself. So if an employee can identify an allergy that could be activated by the vaccine, that is likely, for the purpose of this analysis, at least a disability that we're going to have to accommodate. Number three, contraindications identified by vaccine manufacturers. So there are, at this point, two, it's likely to rise to 3 or 4 approved vaccines as we work through the next few months. And each one is going to have contraindications, meaning medical conditions that could be exacerbated by receiving the vaccine, as identified by the manufacturers. And of course, the manufacturers have an interest in being over-inclusive in terms of contraindications. The more warnings they give about potential side effects, the safer they are. So you could have an employee who says, I can't. The only vaccine that's available to me right now is the Moderna one. It has contraindications for my condition, and as a result, I can't receive the vaccine. And then the last one I've listed here is anxiety. This is one of those really difficult ADA issues that we face, which is that anxiety is something that everybody encounters from time to time. Some individuals have anxiety disorders which do rise to the level of a disability. It can be hard for us as employers to distinguish between the two. And so an employee tells us they have an anxiety disorder, we at least have to get into the interactive process with them to see if we can accommodate it. You could certainly see employees who say, I am anxious, I have an anxiety disorder, and I'm fearful of needles. I'm scared of getting the vaccine. And that could potentially be a great number of people who claim, I'm anxious and I'm scared of getting the vaccine. I don't want to get it. Please accommodate me. So these are the kinds of disabilities that could qualify for receiving the accommodation. But we still have to go through what the accommodation would be, even if we find that we have to respect this disability. Craig, if you could go to the next slide.
Well, Michael, we got a question that fits into this slide, so I'm going to go ahead and ask the question. The question was whether pregnancy would be covered by this list of potential disabilities.
Well, that's a really good question. So pregnancy itself, no, because pregnancy is not a disability. It is itself, it should be noted, protected by the Pregnancy Discrimination Act. And so we have to be mindful about discriminating against pregnant employees when it comes to things like leave. But pregnancy is not itself a disability, so pregnancy itself does not need to be accommodated. On the other hand, medical conditions that a woman is facing because she is pregnant could be disabilities. And so if a doctor says, if a woman comes to us and says, I don't want to be vaccinated just, because I'm a woman, because I'm pregnant, we are not in that moment immediately in accommodating mode. However, if that woman can present a doctor's note saying this woman is dealing with these side effects or these issues connected with her pregnancy, she's having a difficult pregnancy and she's at risk, then that condition, which is associated with the pregnancy, is likely to be a disability that we'd have to accommodate.
Okay.
Okay. So, Craig, if you can go to the next slide. So this is our discussion of the disabilities. It is likely that some of your employees will be able to identify these genuinely or because they don't want to be vaccinated, and so they're looking for reasons not to be. The question then becomes, well, what do we do about it? One option, of course, is to just allow them to not be vaccinated and to come to work and continue on as usual. The other possibilities that I'm thinking are going to be more attractive to you are excluding the employee from the workplace, and maybe in that circumstance, allowing them to continue work remotely, or terminating them because others have returned to the workplace and we're trying to get back to business as usual. And if this employee can't be vaccinated, then we can't have them in the workplace and we need to replace them. That isn't necessarily going to be an option. And so you need to proceed really slowly through this analysis to determine if you get to the point at the end where you can terminate the employee, if that's what you want to do. Craig, if you go to the next slide. So employers are required to provide accommodation to employees with relevant disabilities. We've talked about what those disabilities would be, and the most likely accommodation is going to be the employee not coming to work at all, which is maybe an option that you don't want to have to accommodate, which we're going to talk about in a minute. So then the question is, well, what do? We don't want this employee to come, and at the same time, they refuse to be vaccinated. There is one more saving grace here, which is while you are required to provide accommodations to employees with disabilities, you don't have to if allowing that employee into the workplace presents a direct threat to themselves or others. And a direct threat is defined as a significant risk of substantial harm to the health or safety of the individual or others. Now, COVID-19, contracting the virus and potentially dying from it, is a serious harm. So the threat that these employees will get will get the coronavirus if they're at work because they're not vaccinated is likely to be a direct threat. But again, there's kind of more tentacles to this that we need to consider. So let's go to the next slide. The direct threat analysis is case specific. And by that, I mean, we can't simply say, okay, an employee who comes to the workplace unvaccinated is a risk to others, because it's a practical matter that might not really be true. And here's 3 examples where it probably wouldn't be. So if the usual working environment for the employee, so not the accommodated one, but the usual one, imagine the pre-coronavirus working environment, doesn't involve the employee interacting with other people very much, then they are not, in fact, a direct threat to anybody else, even if they're unvaccinated. So here's a couple examples. The bus mechanic who works in a shop alone, in a small school division where there's only one, if that person isn't interacting with other employees very much, it will be hard for us to argue that they present a direct threat to other employees. Similarly, for number 2, a records or payroll specialist who works alone in the central office, if your employee is deep in the dusty stack somewhere and interacts with books and files, but not other people very much, then it's going to be hard to argue that they present a direct threat. And then similarly, for the employee who's working remotely, you probably don't have very many of these who were doing this before the coronavirus, but if you do, again, maybe because of another disability, again, it's going to be hard to argue that they are a direct threat to anybody from their home. And in the short term, this is true for employees who have been working from home since the beginning of the virus. If they continue doing so, they don't present a direct threat to anybody either. Next slide. In making the direct threat analysis, there are 4 factors for us to consider. And these are presented to us by the EEOC, and they're not specific to the coronavirus threat. They have been in the books for decades, and this is the analysis that an employer is expected to conduct when determining whether an employee with any disability can come to the workplace, given the threat that they present to other employees. Number 1, the duration of the risk. Number 2, the nature and severity of the harm that will arise if the risk, in fact, happens. If the bad thing happens, how bad is it going to be, in other words? Number 3, the likelihood that the potential harm will occur. And number 4, the imminence of the potential harm. Now, as I said, these rules were designed to be a kind of a one-size-fits-all for any kind of disability. And it's easier, I think, to imagine, to think about these factors with disabilities we're used to dealing with more often. So let me give an example. If you have an epileptic employee who works in a safety sensitive position, this analysis proceeds somewhat more naturally, because the concern is that that employee, let's say it's a crane operator. I realize this isn't really a natural fit for schools, but I think this is the kind of prototypical case that's easier to understand. If you had a crane operator, or I'll say a bulldozer operator, and he has an epileptic seizure while operating the bulldozer, he could hurt himself or somebody else. And you could go through these prongs here of the test and kind of work out how serious the threat is. I think it's a somewhat less natural fit for the coronavirus, but why don't we go through each one quickly? So the duration of the risk. And the risk is that the employee would come into the workplace unvaccinated, and B, I would say, this is, I think, the major risk, carrying the vaccine, not exhibiting symptoms for it yet, and will pass it on to somebody else. That risk is a real one for as long as the coronavirus is something for us to deal with. So I would say that risk is very serious now, but as more and more people become vaccinated, and we hopefully develop herd immunity, and this goes the direction of measles or polio, hopefully, then it's going to be more and more rare to find somebody who has it. And so the likelihood that the employee who is coming to the office or coming into work unvaccinated would be carrying this and not know it becomes less and less. So I think the duration of the risk is pretty high right now, but as time goes on, it's going to diminish. The nature and severity of the potential harm is, I would say, serious, in that if the employee who's unvaccinated were carrying the virus and passed it on to somebody else, the harm is serious for the reasons we know, which is that person could be hospitalized and could even die. The likelihood of the potential harm, I would say, is similar to the duration, meaning it's highly likely, or at least somewhat likely now. But as time goes on and the virus hopefully fades away, the possibility that the employee is carrying the vaccine but doesn't know it and could pass it on to someone else, that likelihood goes down with time. And then for the imminence of the potential harm, and I think the way that prong comes into effect here is the question of how imminent is it that the unvaccinated carrier of the virus would pass it on to somebody else. And, as we know, that has varied at different times during this pandemic. The possibility that the employee would infect, or, that another employee could contract the virus is pretty high. I would say that the harm is imminent, meaning that an unvaccinated employee who is carrying the vaccine could very easily pass it on to somebody else for all the reasons that we've become familiar with. If somebody else is in the room with that employee for 2 hours in close contact, then the likelihood of passing on the virus is pretty high. In other words, the potential harm is imminent in that circumstance. Craig, if you could go to the next slide. So what we've been talking about so far is the threat that the unvaccinated employee poses to other employees, and whether we can keep that employee out of the workplace because of it. Now, I think there's this other issue, which is, well, what about the risk that the unvaccinated employee poses to himself or herself? Because I think this is actually the bigger risk. If everyone else is vaccinated, or even if a lot of other people are vaccinated, they're not as much at risk. They've been vaccinated. They can't catch the coronavirus. The real risk is the employee who isn't vaccinated and could get it from, say, a student or anyone else in the workplace who also isn't vaccinated and is carrying the illness. The ADA does allow us to consider the health and safety of the person who's asking, in this case, to come to the workplace unvaccinated. So we do have a basis for saying to this person, you can't come into the workplace because of the threat that you will get sick. The ADA allows for that. Notably, however, when the EEOC issued its guidance, which I mentioned in the beginning of this presentation a couple weeks ago about COVID-19 vaccination programs, it didn't address this question. And I think it's a risky one, or I guess I should say, I think it's a risky play, because the point of the ADA is to provide accommodations to employees who need it, to disabled employees. And so what we would be saying, in effect, in this circumstance is, we understand that you have a disability and that you can't get vaccinated because of it, but you can't come to work for your own good. And that's a difficult thing to say. And from a legal standpoint, I think it's a difficult kind of argument to make. So again, and to go back to what I'm saying is the prototypical case of the epileptic employee who operates a bulldozer, it's easier for us, I would say, to that employee, you shouldn't be operating a bulldozer. This isn't the right kind of job for you, because if you have a seizure and you run into a building, a lot of people could get hurt. In our case, with the COVID-19 vaccination, what we'd be saying to the employee is, well, actually, there probably aren't that other many people who are going to get hurt because they're going to be vaccinated. It's really only you who's going to get hurt. And again, I think that's a tough case to make to the employee, and I think it's going to be an unpleasant one to try to make to the court or to the EEOC. But I think we can and we should, if we are faced with a circumstance where there is an employee who refuses or cannot get vaccinated and demands to come into the workplace, we can fall back on this reason, which is you're a threat to yourself. The other issue here, of course, is that we're not necessarily talking about a workplace that is entirely vaccinated. There may be other employees in the buildings, to say non-teachers. Teachers are going to get vaccinated early, but other employees or even vendors, again, let's say like the FedEx guy who comes in to deliver a package, or even the more glaring example, which is all of the students who haven't gotten vaccinated yet. If we're allowing those unvaccinated people to come into the building, again, it's going to be hard for us to explain why the unvaccinated employee can't come to the building. Craig, if you can go to the next slide. But let's imagine the circumstance in which we have an employee that we've determined is going to be a direct threat because of the particular conditions of their workplace. We can tell that employee, we recognize that you have a disability, but we can't allow you to come into the workplace. We would accommodate you in not getting the vaccine, but we can't allow you to come to work. So then the question is, well, where does that leave us? If that employee has been working remotely, at least for the duration of this semester until the summer, it might be easiest to just allow that employee to keep doing that. Because we do have to consider what kinds of accommodations of this person's job can we provide. And if they and a lot of other people have been working remotely for the last few months, it seems natural to say you can keep doing that. Or another way to put it would be hard for us to explain why we couldn't accommodate that person for a few more months, given that we've been doing it for everybody for several months. Secondly, even if we don't feel like we need to do that, we don't feel like we need to allow them to continue to work remotely, and I think we, especially come the fall, can start saying we're not going to be doing that anymore. That doesn't mean we can necessarily terminate the employee, because we have to consider other kinds of leave that employee might have. So if an employee, let's take again the employee who has cancer and is receiving chemotherapy and can't receive a vaccination because of the chemotherapy, we can exclude that person from work. We can't necessarily fire them because they would be most likely entitled to FMLA leave for 12 weeks. And if they're done with their chemotherapy by the end of those 12 weeks and they can get the vaccination at that point, then that would be good for everybody, and we would probably welcome that employee back at that point. The point here is, just because we exclude someone doesn't mean we can necessarily terminate them. We still have to go through the whole list of things that we normally consider from any other employee that presents a medical condition. Are they entitled to some other kind of leave, like FMLA leave or the Families First Coronavirus Response Act that we've all become familiar with? The employee might be entitled to leave under that act as well. Next slide. This one I've mostly covered already. I think the way that a lot of this falls out, Craig and I can discuss the details of this a little more once we get into the Q&A. An employee will likely have a pretty good case, at least over the next couple of weeks, if not all the way through this school year, that they should be able to work remotely. Though I'll say not necessarily. If all the other teachers are back and we're not doing this anymore, then we can require this in person to either get vaccinated or take some other kind of leave. We don't necessarily need to allow them to keep doing their job remotely. I think this analysis becomes cleaner once we get to the fall, when hopefully everybody's vaccinated at this point, all of the teachers, all of the school employees, all of the students, and we are trying to get back to business as usual. At that point, it will be easier for us to say that the employee who needs to work remotely presents an undue burden. That's the term under the ADA, an undue burden to us. We can't keep allowing them to do that. It's hard for us to make that case now when a lot of employees have been doing it. Come the fall, when again it's back to business as usual, hopefully it will be easier for us to make that case. Next slide. All right, I'm going to wrap up with just a couple other ADA issues before I turn it over to Craig to discuss the religious bases for accommodations. First thing I want to note here is that everything that I've been describing is what the interactive process looks like in this scenario. Hopefully you all are familiar with the interactive process, and I just want to identify here that that's what we're doing. And so you want to treat this process like you would any other employee who presents a disability and is asking for an accommodation. Have them identify what the disability is, ask them what kind of accommodation they want, consider whether you can provide it. If not, consider whether there's other kinds of accommodations you can provide, and document all of this. That'll help if we have any kind of dispute later on. Number two, the EEOC has said that employers themselves can administer the vaccine. But I've been talking today under the assumption that somebody else, a doctor, is going to be providing the vaccine away from schools. If you as a school division actually want to provide the vaccine, be administering it to your employees, there's another group of considerations that we would have to consider. I'd say call us in that circumstance because it's more complicated. Assuming instead that you're going to have other people administer the vaccines, that begs the question, well, how do you know if one of your employees actually has been vaccinated? And the EEOC has said clearly it's okay to ask for proof of vaccination from the employees. That's not, an ADA issue or a HIPAA issue or anything like that. It's okay to ask them for proof of vaccinations. If they give you paperwork in that respect, you then need to consider, well, what do you do with it? And I would encourage you to put it in this employee's medical file. I'm distinguishing that from a personnel file. The ADA anticipates that an employer would have both. The idea here being that lots of people might touch personnel files. And medical records are sensitive, and we don't want them to be that easily available to people. They should be accessed on only a need-to-know basis. And so medical records are expected to be in their own file, apart from the personnel file. And a vaccination record like this, I would encourage you to put in the medical file. Okay, well, that's everything on the ADA front. Craig, I'm going to pass it to you to talk about religious accommodations.
Thank you, Micah. The other major exemption from receiving a vaccine is under Title VII. And as I'm sure everyone on this call knows, Title VII has been around for 50 years. It is the federal statute that says that an employer cannot discriminate on the basis of race, sex, religion, or national origin. So we're talking about religion because that's the one that comes into play here. The general principle is very similar to the principle that you just heard under the ADA. And that is that an employer must provide a reasonable accommodation to an employee who has a religious objection to receiving the COVID-19 vaccination. Now, the question then would arise, of course, what kind of religious objection would require an accommodation? Well, the regulations under Title VII state that any kind of sincerely held and that's the word they use, sincerely held religious belief or practice or observance would require an accommodation. You know, the religious accommodation that we most often think of is accommodations for services that occur on particular days or particular religious holidays that people don't want to work, whether, you know, they're Muslim holidays, there are Jewish holidays, there are Christian holidays, and those days are, if an employee wants to be off work, it's pretty easy to accommodate that. And that, so when we're talking about accommodation, that is normally what we think about, but it does apply in this COVID-19 context. So what can the employer do? Well, and let me go back to this this slide. Anything that is sincerely held, even if it's not based on a traditional religion, can apply. And I'm going to talk about that more in a minute, but I want you to get that concept in your head that we're not just talking about somebody who's a Baptist or Wiccan or some traditionally held religion. So an employer may require an employee to validate in writing that, number one, the relevant religious belief they exert is in fact sincerely held. So they've got to tell you what the religious belief is, and they got to tell you that that religious belief is sincerely held. Of course, what the religious belief is I have a religious belief that I shouldn't be vaccinated. And then secondly, that the religious belief applies to the COVID-19 vaccination program. Now, what does the employer do with that? Well, interestingly, employers really don't have much of a basis for determining whether that religious belief is sincerely held. A religious belief under the regulations under Title VII state that a religious belief can be sincerely held even if it doesn't align with a major religion. So you don't have to say, well, this is the practice of our Catholic Church diocese, or this is the practice of the Baptist Southern Convention. You don't have to show that it aligns with a major religion. Even if it is inconsistent with the self-identified religion. So interestingly, even if they're Baptist and they say, well, you know, the Southern Baptist Convention, let's say the Southern Baptist Convention comes out and says, we really think it's important for people in our denomination to be vaccinated. And somebody says, well, that's not what I believe. And I may be a Baptist, but I'm not following what my religious organization is espousing. That could still be a sincerely held belief. If the employee doesn't regularly attend a house of worship or otherwise engage in religious observances, you can't say, well, you know, this person hasn't been to church or synagogue or whatever for a year. That doesn't matter. And so what happens then is the threshold for the employee to assert a religious exemption becomes very low. To be able to say, I have a religious belief, and that religious belief includes that I shouldn't be vaccinated, then there you are. They've checked the box. Now, you can test whether it is in fact a religious belief by having them make this written statement. Maybe they end out saying that really it's a political belief. You know, you've got somebody that says, well, this was all done during the Trump administration. I don't trust the Trump administration. Or this is all being carried out now by the Biden administration. I don't trust the Biden administration. So I don't trust their vaccine. That's a political belief. That's not a religious belief. Maybe there's a cultural belief. Well, I just don't believe in vaccines in general. I think that we should have herd immunity to all of these diseases and not vaccinate against them. That's a cultural belief. That's not a religious belief. Or it could be a scientific objection. Well, I don't have any trust that this vaccine is going to work anyway. That's not a religious belief. That's a scientific belief. So if the stated belief that the employee gives you is not actually being asserted as a religious belief, but rather is being asserted as a political, cultural, or scientific statement, then you can deny the exemption based on that written statement. Now, once the employee has asserted the religious belief, the next question is, to what extent do I have to accommodate it? And how do I accommodate it? And interestingly, the answer to that is very similar to the answer that Micah just gave you under the ADA. And that's kind of helpful because there are ways in which you can sort of bundle your analysis together and not have to run through two totally separate analyses once you found that the exemption applies. So an employer doesn't have to allow an employee to exempt themselves from the vaccination program based on the religious belief if it imposes an undue burden on the workplace. So we're right back to that undue burden analysis that we had under the ADA. So what is the undue, what's the undue burden? Well, if we went back to the undue burden slide for the ADA, that would be the answer. You consider the health and safety risks presented to this employee and to the other employees, and quite frankly, to your larger school environment, if the employee reports to work without receiving the vaccine. So it's what are the health and safety risks? If the employer concludes that the unvaccinated employee poses an undue burden or undue risk on the workplace, then the employer at that point can exclude the employee from the workplace. But excluding the employee from the workplace doesn't necessarily mean I'm going to fire the employee. It just means they're excluded. They may be accommodated in another manner, such as remote work. We've been doing that now for months, so we have to consider that. Can the work be done remotely? And the answer might be one answer for teachers, where we say, well, a teacher needs to be in the classroom in order to do classroom management. So we're not going to grant an exemption for a teacher, but would we grant an exemption for the records clerk that Micah mentioned? Or maybe the employee can just take some leave, since so that they say, well, I've got leave saved up and I'm just going to use my leave during this period of time. If the employee can continue to perform his or her job remotely, that probably is going to be your best option, at least until the fall. Now, in the fall, based on what we know right now, teachers and people who have direct contact with students are going to be in the quote 1B group, which is going to be the next group who will have vaccines available to them. So the 1B group should be getting their vaccines in late January and February. And so within the next month, hopefully a lot of your employees are going to have access to the vaccine, but the students aren't. So you're still going to have, to the extent you're having in-person education, you're still going to have a lot of unvaccinated people in your building. So it's hard, again, as Micah mentioned, it's hard to argue that terminating people because they're not coming to work works when you've got all of these unvaccinated people anyway. Okay, so that is the overview of the law. What we thought would be helpful would be to just take a minute and talk about not the question of can you do it? We've addressed that pretty clearly, I hope. But now the question is a policy question of should you do it? Should you require the vaccine of all employees? The policy questions aren't legal questions. Lawyers are supposed to answer legal questions, but having answered the legal questions, we can at least tell you what the policy arguments are so that you can consider those arguments and then make your own decision for your own school district. So the question is going to be, it's an opinion issue, it's a policy issue, not a legal issue. Should you require employees to receive the COVID vaccine as it becomes available? So I'm going to argue, and like good lawyers, Mike and I said, hey, either one of us can argue either side of this. So don't take this as our personal opinions so much as we're just trying to give you a clear statement of what the pros and cons are. So I'm going to tell you what the pros are of having a voluntary vaccination program rather than a mandatory vaccination program. And then Mike is going to tell you why you might want to have a mandatory vaccination program. So why not mandatory? Why not rather say we strongly encourage you to be vaccinated? Well, here would be the argument. The polls indicate that 70% of United States residents intend to be vaccinated. That leaves 30% of the population who doesn't plan to get a vaccine. That's a huge number of people. That's about 100 million people. It is relatively easy to skirt a mandatory vaccine because of the health and religious exemptions that we've already described. And as you can tell from our presentation, those ADA and religious exemptions are pretty broad. And it's not going to be terribly difficult for an employee who really doesn't want the vaccine to pigeonhole him or herself under one of those exemptions. Particularly in the current school year, the students are not going to be vaccinated until late in the spring or even the summer. So your buildings are going to be full of unvaccinated people anyway. How does having a small group of unvaccinated teachers or employees really add any significant incremental risk to the spread of the virus? Do these unvaccinated employees represent a quote significant health threat? Because that's the standard. If you think they represent a significant health threat, are you going to keep all the unvaccinated students at home because don't they present the same significant health threat? Which for this year at least is going to mean you keep every student at home because every student is going to be unvaccinated. Now, if you say mandatory, but as we've described, the leakage is going to be like a sieve. What are you doing? What do you accomplish? To me, you're accomplishing a morale and disciplinary issue among those who don't want to be vaccinated that you can avoid. The unvaccinated person is more of a risk to him or herself than to others if you continue mask requirements, which you should. For the remainder of this school year, at least, masks, social distancing, and other protocols should remain in place, even for vaccinated individuals. The vaccine is not 100% effective, so even a person who has had COVID or has been vaccinated should continue to comply with all health and safety protocols. There's no real risk of litigation with employees because they're covered by workers' comp. They can't sue you if they get sick at work. There's not a litigation issue. It's going to be a workers' comp question, and it's probably not going to be covered by workers' comp because they're not going to be able to show that they actually got it at work. They could have gotten it anywhere. So the strongly encouraged argument is be realistic, don't be idealistic, don't pick a fight that you know you can't win. Micah, you want to say why I'm wrong?
Yeah, absolutely. So I'd say there's practical reasons and symbolic reasons. Let me start with the symbolic ones because I'm going to follow off of something that Craig said, which is that idealism serves a purpose. It sends a signal to other people. And so I think there is some symbolic value in having a mandatory policy. Maybe you end up with the same number of employees vaccinated for the reasons Craig was just saying, which is that a number of them ask for exceptions. But I think there may still be value to having a mandatory program, even in that circumstance, because you are sending a signal both to your workforce and to others that you think the vaccine is important and that people should get vaccinated. It also has some practical value, I think, because I think a mandatory program, again, despite all of the exceptions that we've been talking about today, is still most likely to maximize the number of people who are vaccinated. And I think that's because of imagine the employee who's not particularly enthusiastic about the vaccine. And so if only encouraged to do it, may not get it, but isn't prepared to break the rules and doesn't feel so strongly about it that he or she is actually going to ask for an exception. So I think a mandatory program may capture a few employees who are kind of on the fence about it and are more likely to get it under a mandatory program than they would be if they were just strongly encouraged to get it. I think there could be some liability limitation in having a mandatory program. This follows off of the kinds of instructions that we were giving over the summer. If you have a mandatory program, you couldn't possibly be doing more to get your employees vaccinated. And so if you ever face a negligence case, and I agree with what Craig said, these are going to be few and far between for workers' comp reasons. But if there's a student who gets sick and had contact with an unvaccinated employee, they might argue that the school's at fault because the school didn't require that person to be vaccinated. And I would rather be able to say, well, we did have a mandatory program, we just had to give an exception in this case, than to be able to say, well, sorry, Your Honor, we were just strongly encouraging it. And this employee didn't take our encouragement. And then I think the final reason is one that's maybe not specific to a school division, but really to just the community at large. You know, the adage I've heard recently is vaccinations don't work. It is vaccination programs that work. Vaccinations just help the individual person not get the virus. It's only widespread vaccination through mandatory vaccination programs that actually kill the virus and allow for herd immunity in such a way that the virus disappears. And school divisions and school superintendents have a really strong lever in making rules for their workforce. And we can help our communities develop herd immunities by making those who are under our control get the virus. Again, not necessarily because it's going to make a big difference for the safety of the school, but rather because it might make a big difference for the safety of the community at large. So the more people that we can get vaccinated, the better. And let's use the leverage that we have, which in this case is our rules that we can make for employees as superintendents. So that's my case for a mandatory vaccination program. Craig, I see we have about, yeah, exactly. We have about 5 minutes left. So let's move to the question section. Craig, if you want to move to the next slide. So, you know, we've given you the facts. We've given you our opinion. Now is the time for the letters to the editor. What questions do you have? And we have a few. Craig, I was looking through the questions while you were doing your piece, and a lot of them fit into one type of question that I want to pose to you because I think I've talked about it some, but it might be useful for them to hear it from you as well. And the issue is this, which is, well, yes, we have been accommodating employees over the last few months by allowing them to work remotely. But we want to be moving to in-person instruction, or we already have. We've already moved away from allowing this kind of remote work. So do we really have to allow an unvaccinated employee to work remotely, given that we've required so many others to come back to the schools? Do you have thoughts on that, Craig?
I do. This is where no good deed goes unpunished. Because you have been accommodating the people by allowing them to work remotely, it's difficult to argue now that would create an undue burden, because why wasn't it an undue burden in November, December, January, and now it's suddenly an undue burden in February or March? And so the fact that you have been permitting it for months now makes it much more difficult to suddenly draw a line in the sand and say, all right, now we're changing everything. I think as you go into the fall, that changes. I think you can definitely reset the clock for fall and say, by then we're going to have widespread vaccination. I think any requirement that you would accommodate in the fall simply because somebody is choosing not to get a vaccine, I think that argument is going to be much stronger for you under those circumstances, and you're much less likely to get either an ADA or a Title VII claim that would stick. Michael, what are your, anything you want to add to that answer?
No, I think that's exactly right. I mean, I think that, you know, basically that to make this whole thing work over the last couple months, the EEOC has created an environment in which we feel like we need to accommodate employees by allowing them to work remotely. So right, it begs the question of, have we created a completely new normal? We never would have imagined a teacher working from home and Zooming into her classroom 6 months ago. Is that the new normal that we're going to have to deal with going forward? For the reason that Craig said, which is that, well, it's worked for the last couple of months. What's the argument for not allowing it anymore? I think that's exactly right. I'm hopeful that we will get some signals from the EEOC over the next couple months saying something to the effect of, that was a unique circumstance. But going forward, you can move back to business as usual, where you expect workers to come into the workplace. And if they can't, they don't have to be accommodated. There's only 2 minutes left. Why don't I just take one of these really quickly? Question is, can we require some employees to get vaccinated and not others? And the answer to that is yes. And there's some logic in that, because there's some employees who have more interaction with other students or other employees, and there is some wisdom in requiring those employees to be vaccinated and not others. The only caution I would give here is, you always want to be mindful when you're drawing those kinds of lines in your workforce, who's ending up on each side of the line. And if let's just put it this way, if the only people who got vaccinated were nurses in your school division, and 90% of them are women, you could have to deal with an issue from one of them saying that this is only something we're requiring of women. Obviously that would be kind of silly in that case, but it's like any other kind of discrimination analysis. Anytime you distinguish between your employees under a policy, you just want to consider if disproportionately certain groups of employees are ending up on one side of the line as opposed to another. So I see it's 10:59, so I think it would be smart for me to pass this back to Andy in case you wanted to give any announcements at the end. Thank you all for listening.
Micah and Craig, thank you very much for the excellent presentation. As I said earlier, Micah and Craig are going to respond to the questions that they didn't address during the webinar in writing, and we'll send those responses to you by email that you used in your registration. So if you want, I'll leave the meeting open just for a minute or so, and if you haven't posted a question, do so. We'll capture those. We'll send them to Mike and Craig, and they'll respond to those, and then we'll turn those right around and send them to you. So thank you all for joining us today, and we look forward to seeing you on the next VAS webinar. Take care. Looks like we still have questions being entered, so I'll leave it open for about 30 more seconds and I'll end the webinar.
Good job, Andy. I think this was certainly a timely topic for everyone who joined.
That was great. Those guys do a great job.
Yeah, they tag team real well.
I like their going through the legalities and then the policy advice and the pros and